I'm the founder of MyCludo, but I have a long history in working with investigations and in the investigations industry that's gone along some 20 years now. I have a number of postgraduate qualifications ranging from forensic psychology, investigations and education. I've been a sworn police officer in the UK and in Australia. I've lectured around the world and also given numerous presentations at different conferences around the world from time to time. I did for a number of years, travelled around in that university role lecturing to police detectives. So I have the honour of having taught detectives in every state and territory in Australia, which was it's a very informative experience to do that, to be able to capture that cultural difference around such a large and diverse country. And I've been a private investigator with a license since 2003, you'll see on there. And as a consequence of my work in workplace investigations, I have conducted hundreds of investigations into sexual harassment and sexual misconduct. And I'm aware, obviously, that many of the people online today are also in that position, very experienced people with lots of experience dealing with sexual harassment. So today's, the questions that we're looking at today are not necessarily addressing your straightforward cases of sexual harassment, but those are a little bit more challenging. So just looking at my first slide here to talk about the various characters in this picture. We have obviously Geoffrey Rush, who's the subject of, I think, Australia's largest compensation payout for defamation, just recently upheld in the High Court. That involved Erin Jean Norville, who became a witness in those proceedings, and we'll talk a little bit more about her and why her role is so important for us when we're dealing with those initial complaints. And obviously other famous people that have been involved in sexual harassment complaints. Gretchen Carlson, 2016, launched major complaints involving the bosses of Fox News. Luke Foley became a respondent in allegations a couple of years ago, and most recently the matters relating to Hayden. So all of these very high profile cases reflect just a tiny window on what's actually happening for normal people in workplaces across Australia and the globe in regards to sexual harassment. So it raised some questions, and these are the questions that came up for me. What is trauma-informed investigations and victim-centred response? So we've heard that a lot in the press just recently, but what exactly are they? and how do we respond when the complainant doesn't want to make an official complaint? That's clearly an issue. How do we support victims and the accused when the allegations are not yet substantiated? So once we start the investigation process, or managing the complaints, but how do we manage all of that before we have a clear outcome? What if both parties seem equally to blame? Now, this has been an issue for me in a number of my more recent investigations that I've done, where and it's probably a reflection of the role of an external investigator, as we probably disproportionately get involved in cases that are quite difficult to determine and where there may be the apparent culpability of both sides. And in fact, I've had a number of investigations where the complainant becomes a respondent and an organisation proceeds with sexual harassment over both parties. The fifth question that came to my mind is about libel and defamation. So obviously in response to the matters involving Geoffrey Rush, what vulnerability do we have if you're a HR manager or an investigator, and what's the chances of being affected by a defamation complaint, and how do we respond to that, prevent it from happening? What is the difference between sexual harassment and sexual assault? So in the Hayden case, we note that it was investigated for sexual harassment, but then it's referred to the police for investigation of sexual assault. So gaining a really clear understanding of the difference between the two and when organisations need to make a change or need to identify that sexual assault has actually occurred and they're not dealing with a non-crime, an administrative issue of sexual harassment rather than assault. The 7th question that came up is, if police are involved, does that mean the employer can't act? Now that's obviously connected with question 6, which is, if we don't identify for years that an issue actually is sexual assault, when can, how does that impact on an employer's options for dealing with the matter? And question 8, who's qualified to undertake administrative investigations? And again, the Hayden press relating to Hayden has identified this as a question, not necessarily an issue, but has definitely raised it as a question. So arguing his defence have argued that the person responsible for doing the investigation was not qualified to that task. So we're going to have a brief look at that as well. And my final question was, where do we find someone who's qualified to provide a victim-centred investigation, whatever that is, whilst maintaining that legal scrutiny? Where do organisations find them? So we're going to go through those 9 questions, and I may from time to time ask people for their input. So if you, I know most people will be muted at the moment, but if you wanted to ask a question, please unmute yourself or put your hand up if that's possible, and we'll make that open. So I also have to apologise for the distinct lack of images in my presentation today. It's very much a word-based presentation, but I hope to get some input from everybody. So this first question is, what is trauma-informed, victim-centred? What is it that we're supposed to be doing, both for organisations and investigators? So when I started looking into this, really wanted to identify that there's 2 distinct things. So one is a victim-centred approach, and the research on that and the movement around that is around managing the initial complaint and providing support for complainants. So victim-centred approach is talking about how we receive a report, supporting and encourage people to make complaints, and then offer them support and accommodate the victim's needs through that process. I also came across this useful acronym called BLOG, which is actually, there's quite a lot of literature in the victim-centred approach through looking at universities, and globally universities have really picked up their game in the last couple of years in terms of dealing with sexual offending on campuses. And so this term has been captured, which I think has some relevance for workplaces as well. So when somebody makes an initial report, the aim is to believe them, to listen to them, offer them support and options, so go through what their options are, and get support for yourself. So that was the other thing that's come through with a lot of the reporting process, is that people that receive complaints of sexual offending, and including harassment, may need support themselves to deal with that. But that's obviously, the more you are the recipient of these complaints, the more likely it is that you're going to need some sort of support for yourself. So looking at trauma-informed work relates to investigations, and that's when the actual investigative work needs to be trauma-informed. So what does that mean? Well, what that means is that the investigators, out of preference, we want to have investigators that understand how trauma might impact on the victim and how the victim may present themselves. So we need to avoid false assumptions about a victim's response. So this comes out in lots of different ways, but mostly the 2 opposing ways, which is somebody having an excessive emotional reaction to the behaviour that's been imposed on them, or somebody having no reaction at all, so no emotional reaction, or seeming to have no emotional reaction. So that both of those options and anything in between is possible. somebody who's experiencing trauma from an event may well withdraw or become a difficult person to deal with from an investigator's point of view. They may withdraw from the investigation process out of a self-preservation or a traumatized response. They may refuse to speak to the police for the same reasons or for other reasons, and we often don't know what those reasons are going to be. Another aspect of a trauma informed approach is understanding that the story will unfold over time. Now, I recall very clearly as an early investigator in workplace spaces, assessing the reliability of somebody's evidence by the number of times the story changed. Okay, so that's a fairly common measure, but if we're dealing with a traumatized person, their story may well change over time. And one of those reasons is because when we first disclose something that's difficult and very personal, we want to just test the water and disclose a small amount, and then wait to get some feedback on how that's received, whether it's believed, whether you're supported, before we disclose more. So that's a very common pattern which investigators and HR managers may confuse. The final point there is about how trauma impacts on memory. So a lot of our harassment, and this goes for bullying victims as well, a fair proportion of those may well have been victims before to other either similar behaviour or more serious behaviour, and may be traumatised from previous events. And so that trauma impacts on the behaviour that's imposed on them now with the matters that we might be investigating. So that's why you get some extreme emotional reactions to what seems like fairly, fairly mundane behaviour that you might be dealing with now, but their reaction may be quite extreme because it's re-traumatizing them or it's compounding the trauma from a previous event. So how that impacts on memory is that they may experience like flashbulb memories. So there'll be some details that are extremely well remembered, very detailed, other memories that completely vanish. So their stories can be patchy. They can find it difficult to recall things in any kind of chronology or with any kind of structure or sense. Those are normal responses to trauma. So it's important for investigators to understand that. The other part of trauma-informed investigation, which is really critical, is about reframing our questioning so that we don't ask questions that victim blame. So as an example of that, obviously in many of the matters that we're dealing with, there becomes a point, behaviour may have been reciprocal or seemingly reciprocal for a period of time, and then things change. So this question, why didn't you tell him to stop, or why didn't you tell them to do something else? That the structure of the question implies to the victim that they should have done something. Whereas we can reframe our questions to obtain the same evidence, but not with attaching the same kind of blame or shame to the person reporting to us. So we could change that into, what conversation did you have about how you were feeling? Okay, and they may have had no conversation at all. Okay. So the, actually I'll just go, I can't go back. I did want to just raise a question there I probably can actually, just in regards to, in regards to victim-centred approach. I was having a conversation with Claire Alder, who's on the line now. We were having a conversation yesterday about victim-centred approach and what that means. And I think really gaining clarity over it's quite important, because if you misunderstand what victim-centred means, it would be very easy to cross over into being biased. And so victim-centred is not about siding with the victim. And certainly from an investigator's point of view, you want to be very clear that you don't represent that you're siding with the victim, because that will cause all sorts of problems with procedural fairness. So I don't know if anybody wants to comment on that, whether they've had any experiences that way or any observations they want to make. Okay.
Just going to say, Harry, it's Melinda here.
Hi, Melinda.
I find even the way that you respond to what they tell you, if I'm too positive, or if I give too much body language back, whether sharing a victim or even a subject of complaint is sharing their story and what their experience was. If I'm too okay, yes, right, things like that, that can actually confuse them as well and make them think that. So it's really important, I've learned, to hold back on what my responses are in those ways as well.
Yeah, and you're right, Melinda, and it's been the subject of proceedings in the past, where that kind of interaction from an investigator has been found to be procedurally unfair when it's contrasted with a very different approach to the person who might have been accused. So I think as investigators, we need to be very, very neutral in the way we speak, but that doesn't mean that we can't change the way we ask questions. And so I think that getting the difference between victim-centered being where management comes in, and the support that's provided by an organisation, as opposed to the role of the investigator. So the investigator is trauma-informed, which is slightly different. So I'm just going to move through. Sorry if I'm flicking.
Harriet?
Yes.
Just in terms of a couple of things with the trauma-informed, it occurs to me that although as investigators, as you said, we need to be alert to that and not necessarily confuse or make comments on someone's credibility because there might be some inconsistencies in terms of remembering a traumatic incident. But in terms of sexual harassment, what I've come across and don't necessarily have a definitive answer for is how can a respondent, or should a respondent, be alert to somebody's particular trauma that they've gone through? So I've done some cases where you've got a comment that is made to a work colleague that maybe might appear to be not necessarily innocuous, but not necessarily entirely inappropriate, objectively inappropriate. But for that person, because of the trauma and the particular history that they've gone through, that comment triggers a very real and very powerful response. So in determining and looking at the definition of sexual harassment, where it's the subjective, but then balanced against that with what a reasonable person would consider, it, knowing all the circumstances, whether that comment would be appropriate or not. How do you put that person's trauma and history into the mix? And should somebody in a work context always be alert to the fact that anyone they speak to might have, for example, been a victim of a sexual abuse in the past, or that they themselves have had some traumatic incident that could potentially trigger a response?
Well, I think the important thing is actually being aware. I don't think people in the workplace need to be aware, and I think often as investigators we don't need to be aware. I think what's shifting is the expectation that we can provide care and support to a person while still ensuring on a objective, factual basis punishment of another person that's maybe done something wrong. So I think where we may have been failing is that if we investigated a matter and determined that it was an innocuous comment, we would then criticize the victim for being overly sensitive or irrational. And what we need to do is actually support the person how they present, regardless of whether their response is rational or reasonable in the circumstances. But obviously we can't go and take punishment action against somebody else if their conduct, like the impact may well have been much greater than the act itself would normally warrant, if that makes sense. So I think it's about holding the victim as they need to be held through that process, and not judging them just because somebody else doesn't find that comment offensive. So moving on to question 2, so we will look a little bit more about objective, the difference and things. How should we respond when a complainant doesn't want to make an official complaint? So this is this is always tricky, and it just got a little bit trickier in my view. So this is where Norville comes in. So this is a quote from an article written post to the Rush case. So Norville, I don't know anything personally about the case. I only know what was in the papers. But Norville didn't commence court proceedings. She didn't seek coverage in the media. She didn't intend for her sexual harassment complaint against Rush to be made public anyway. But what she was a key witness in a defamation case. And as a consequence, everything that she experienced became very public and subject to a lot of media. And we would all have come across that comment. She simply wanted her employer to know about the behaviour and for it to stop. And I hazard to guess everybody on this call has experienced that. People don't want to make a fuss. They think there's going to be negative consequences. Unfortunately, they're often correct. And so they don't want to make a scene, but people need to know. So unfortunately, the recent report from the Human Rights Commissioner doesn't really help in this regard, because they haven't really given any steps for how employers should move forward. And in fact, what they've done is create that is very much focused on prevention, which is fantastic, because obviously we don't want these things to happen in the first place. But for an employer that receives a complaint, whether the person wants to make an official complaint or otherwise, the reality is that they have obligations. And so the report just emphasizes the obligations on the employer to create a safe workplace. Employers have the obligation to ensure the welfare of the complainant and of the accused. That's a dual duty of care. They obviously have vicarious liability for other staff, which is an issue, which was definitely going to be an issue in the Hayden case, because if the organisation was aware of some of the early complaints and failed to act, then they're going to be held vicariously liable for subsequent misconduct. The report also places a weight on employers to redress the gender imbalance in workplaces through increasing diversity, and is mooted. Recommendation 17 actually goes to say we want to instill a positive duty to eliminate sexual harassment and discrimination in the workplace. So I can't see any room there for an employer in receipt of information from a complainant that there's sexual harassment taking place. I can't see any room for them to fail to take some action. But what are the options? So I'd like to open this up to any of the participants as well, in terms of realistically, what are the options if an employee doesn't want any action? Going to wait just a little while.
Harriet, I always tell people when I'm doing training in this that getting a sexual harassment complaint or any complaint is like playing pass the parcel with a hand grenade and the pin pulled out. You don't do anything and the music stops, boom. I think if someone's made a complaint and comes and tells you, look, I've been sexually harassed or whatever it might be, the HR person or the manager, whoever has got to make that decision. Even if the person doesn't want to be involved, they can't leave themselves open to be sued, because just because someone says they don't want to be involved on Monday doesn't mean by Tuesday they haven't changed their mind, or they've gone home and spoken to their daughter who's a third-year law student at Sydney Uni who says, no, you must sue, or their best friend who works for Harmers. So I think regardless of the wishes of the victim, the HR person's got to make the decision, weigh it up and take action.
Yeah, Yeah, Phil, that would be very much my view as well. Does anybody else have a view on that?
Hi, Harriet, everybody. I do most of my work in schools, and we've been trying to address some of this stuff in codes of conduct and the conversations we have with teachers before complaints come up, that we talk about a positive obligation they have towards the culture of the school itself, and how when these matters arise, there's an obligation on them, moral obligation, to participate to the best that they can. So we write that into the codes of conducts now and into our policies. And the other thing we try and do is declare from the start that they walk into a boss office, principal or the deputy or even their faculty coordinator's office, and use certain terms, begin to describe certain behaviours, then that's the starting pistol, and the school may then take action to deal with it, regardless of what the person themselves wishes to do. So we kind of forewarn that a little bit and prep them around it.
Yeah, and I think in you know, depending on the nature of what's been complained about, there are all sorts of preventative actions that can take place within a workplace that don't necessarily involve a strict investigation relating to one person's behaviour against another. So there are other options in there, and I would recommend that organisations take a multifaceted approach. But once they receive information that there's misconduct or alleged misconduct happening, they really can't afford to not act. Okay. So this question, how do I support the victim and the accused when allegations are yet not substantiated? Not yet substantiated, that's supposed to read. And a really good premise to handle this one is about do no more harm. So the work, often investigations are criticised for causing harm. And I think it's really, really important that we take stock and plan our approach to achieve an aim of no more harm. And in regards to that, I think workplaces, so not a lot of this is the responsibility of the workplace, not necessarily the investigator. Maintaining a connection between the person and their workplace is very, very critical. We know that through any kind of work-related injury. The longer a person is out of the workplace, the more the harm gets greater and greater. So whichever party it is, it might be all parties, we need to keep that connection. And what I don't see happening very often, but I know it works in other spheres, is the allocation of a support person. So you would probably use this for the more complex and more serious cases, and certainly cases that may involve criminal acts where there's criminal action being taken. But the workplace, in my view, would really benefit from allocating a support person to work and provide support to their employee. But they need to be someone who's never going to be involved in any decision making. So their role is purely the connection and support between employer and employee. If the decision is made to suspend somebody, and suspending gardening leave, move to a different location, put on different shifts, whatever the guise it is, that decision should really only ever be made on the basis of risk. So risk of further harm to a person, other people, or to the investigation. But it needs to be regularly reviewed. Now, I come across workplaces all the time, they just have an automatic response to suspend the person accused. So they suspend them, and then it just goes on, and it goes on, and there's very poor communication, and there's no review. So the risk factors might change, but they don't change the suspension. They keep the suspension in play until the investigation comes to a conclusion. And obviously, if that involves criminal conduct, then they may be waiting for a criminal outcome before they begin a workplace investigation. And so those matters can drag on for years. So I think the status of suspensions in investigations is really important in terms of maintaining the welfare of those parties. We know for sure that just offering welfare through EAP in a letter is not enough. So that is the standard, but it really isn't sufficient. The appointment of an independent investigator from outside the organisation. So I am a firm believer that independence is a key component to gaining the trust of the parties involved in serious complaints. And so they can have faith in the outcome, that it is an independent outcome and not a stacked deck. That's of course where the facts are contested. If the facts are not contested, then you probably don't need an investigation. You can move straight to resolution. Fair process. This again is my belief after a long time of doing this work, that if people believe that they've been part of a fair process, they are much, much happier to accept the outcomes, and there'll be much less emotional distress. The compounding emotional distress that occurs from investigations is often because the investigation has not been very supportive, it might have been accusatory, the process was unfair, those sorts of things. So I think that goes quite a long way. Oh, just dropped off again. Okay. So what if both parties seem equally to blame? Now, this is always a tricky one. In my last few investigations, I feel that I have not really done my best by women's rights, and I've ended up being part of a process that's seen a number of females accused of sexual harassment or poor conduct as a consequences of the complaints that they've raised. But unfortunately, that's the role of the investigators to determine the facts. And if that's what the facts say, then that's what they say. So I think if we're looking at complex complaints, it's really important not to make assumptions. So those assumptions often get made before, there might be assumptions at play before an investigation even gets started. But if you are the investigator, you need to really challenge your assumptions about who's responsible for what, or who's done what, and challenge your own biases because they influence us. We need to establish the facts as best we can and focus on those facts, base our decisions on the facts that we can establish and not on the things that we can't. And obviously that's often easier said than done. We need to look to the true nature of the power relationship between people and also reciprocity. So can we establish from the communication between parties where the conduct has been genuinely reciprocated, or whether it's been reciprocated out of some feeling of obligation? So we see that a lot when young people are involved in sexual misconduct. Where there's an older person or a more powerful person, it's often quite easy to see. But in workplaces with adults, it also occurs as well. There can be obligations placed on adults where they feel that they need to go along with jokes, or along with conversations, along with behaviour, and then they get to a point where that everything changes. So they may have been okay to a point, and then it changes, something subtle changes. And that's our job really, to establish when and where and what changes. We need to make decisions on the conduct of both parties. I'm not really sure what other people think about this, but if you've got two parties that are both behaving inappropriately, then businesses can't really be seen to be biased, or I don't feel that they should be biased, even though we need to support people to come forward to make complaints. But if you have two people, it doesn't really matter what gender they are or how those things have transpired. If they're behaving inappropriately, then they should be treated with some equity in that sense. The case that I'm thinking of, a couple of cases that I've dealt with. One in particular was a young lady who made a complaint with her employer that she'd been taken advantage of by a colleague after a work function. So they'd gone back, the story was that they'd gone back to her place and he'd had intercourse with her. She wasn't really sure about it, but that had happened. Then the following day, it had happened again, and he'd stayed another night. And then on the Monday, she'd come to work and it was all off. But her complaint was essentially complaining of a serious sexual assault. She didn't want the police to be involved, which is fine. You know, everybody's entitled to make their decision that way, but she didn't want to continue working with that same gentleman. And the workplace was presented with quite a difficult situation, because obviously they can't make a person go to the police if they don't wish to go to the police. But they wanted to establish whether their male employee had in fact been guilty of sexually assaulting this other female employee. But as the investigation unfolded, there were other facts that came to light that really indicated that, well, there was a lack of evidence to show that she had been unwilling to engage in the sexual acts, if we could say that. So she'd essentially, the evidence indicated she'd participated fully, other than what she'd reported post the events. The other information that came to light related to the whereabouts of her husband. And in this particular case, her husband had been, there was domestic violence involved, so an unhappy situation. But he had actually been arrested on the Thursday and incarcerated for the weekend, and then came back home on the Monday, which obviously not knowing exactly, you never really find out exactly what happened. But when you put all those pieces together, it did appear to me as the investigator that there was a case of the morning after complaint, and actually she'd probably participated quite willingly in the conduct, but then her circumstance had changed and she needed to be out of what was a very uncomfortable situation. Now, for an employer, it doesn't change the fact that that employee is now in a very uncomfortable situation. And in a way, the sexual assault complaint was actually the employee's way of trying to get out of a difficult situation. But obviously, when you're investigating those things, you've got to be really mindful of the consequences for the male employee of having a complaint of that seriousness made and sustained versus one that's not sustained. So I think the job for us is to really pick through what can be very personal circumstances and try to establish what has happened and what seems fair and reasonable as an outcome. Does anybody have anything they want to contribute on that point? Okay, I'll move on. So defamation. So I have to confess to researching this mostly over the last couple of days. So I'm not an expert in defamation, but the Geoffrey Rush case made me sit up and think. And I thought, oh, it would be, I hadn't necessarily thought about the full ramifications for defamation. And that needs to be a genuine concern for people. So, you know, the question here is, will I be liable for claims of defamation if I make allegations known to an accused before there is evidence to support them? Now, this is an actual question that's been asked of me by people who've engaged my services. So I haven't just pulled it out. So in short, no, because you can't defame. If you're making the allegations known to the person who's accused, you can't defame. You're not actually defaming them. Defaming relates to giving that information to third parties. So there are some buts. In terms of defamation, it involves the communication to a third party, but that can be just a verbal communication. It doesn't have to be published in the paper or on Facebook. It can literally be to one other person. The communication identifies or is about the plaintiff or the person subject who's accused as such. Or the person who will be harmed, should I say. And the communication is defamatory. So does it harm the plaintiff's reputation, hold them up as ridiculed, lead others to shun or avoid them? Now, any sexual harassment complaint is going to do that or has a high likelihood of doing that. And so really the question is, you can't be accused of defaming the respondent by putting questions to the respondent about the allegations. But potentially, if anybody else party to the investigation mentions those allegations to any other third party, potentially they could be guilty of defamation. So there are two key defences that relate to the investigation process. One is this concept of qualified privilege. So a complainant is obliged to tell somebody else who then has a duty to respond. So in this sense, a complainant is covered from defamation when they have qualified privilege. The other one, of course, is if they're telling the truth, which is why the Geoffrey Rush case went through court, because he ran Rush, the newspaper, ran the defence of truth, which is how Norvell became the key witness, because it was her evidence that they were stating was truthful. And I think we can all see the devastating consequences for the complainant in that case. So the Respect at Work report deals with defamation in some quite some depth. So I've recommended this as an issue for you. Have a look at that report, section 5.8. They also raised some recommendations in regards to that. So the law as it stands today, if you share it with a third party, could be subject to defamation. But those laws are already under draft amendments that should make that safer. So the Respect at Work report recommended that they consider some additional issues related to sexual harassment. They also made recommendations around non-disclosure agreements. So that's also worth reading, and if that's an issue for your workplace, to look at that. And recommendation 39 relates to suggestions that the report has put forward to protect victims. Now those that may be giving evidence in civil proceedings, such as defamation cases. So those recommendations are very similar to the protections that are available to witnesses in criminal cases. So giving evidence through CCTV, not being cross-examined in the room, not being cross-examined by people who are defending themselves. So that's the recommendations that they've put in there. All right, so I've just been reminded of the time, so I might just move on a little bit. So what's the difference between sexual harassment and sexual assault? So as we know, lots of sexual harassment complaints contain elements of sexual assault, but I think this is where a lot of the more serious cases come unstuck, because employers, I know they're just human beings, right? We're all just human beings, but often miss the key elements of the difference between the two. So I think there's, I think the world would really benefit for some better education on crimes and what constitutes criminal conduct. So here, the definition between the two: sexual assault, a person intentionally sexually touches another person without their consent. So really it involves the touching, and you can attempt a sexual assault, which may not involve touching, but the intent would have to be there, that there was touch against the person's consent. When we're looking at sexual harassment, it encompasses a whole bunch of behaviours that don't involve physical touch. Unwelcome sexual advances and sexual favours or requests for sexual favours, any other unwelcome sexual conduct. And as we would know, a lot of that now would be through text messages, email messages, sharing images and jokes and things like that, where a reasonable person, having regard for the circumstances, would anticipate the person would feel offended, humiliated or intimidated. And this kind of comes back to what you were saying, Claire, in terms of a reasonable person. So when we're looking at whether conduct does it amount to sexual harassment, it's not just the reaction of the person who was the target or complained about that behavior, but we do have to put, you know, the reasonable person hat on and go, well, given what was known, would a reasonable person have been offended or intimidated in that context? So that's where it comes across. So common mistakes that I've seen: failure to identify that the behaviour may be sexual assault, and as a result, the behaviour gets minimised. So there's a quite a common theme of, oh, it's just sexual harassment, oh, it's just a bit of larking around, missing the fact that if this was a stranger that had conducted that behaviour or conducted themselves in that manner, they'd be straight down the police station and somebody would be locked up for at least the night. So I think employers really need to focus on that when they're doing training. Also, misunderstanding of the role of consent. So I see that quite frequently too. So as we know, there's a lot of relationships start in the workplace. Some of those go on to be long and happy marriages, and some of them end up in a heap on our desk. So I think there is a big misunderstanding of exactly what constitutes consent and where it starts and stops, both by regular people and by employers. So I think it's mindful to think of, consent for a sexual engagement can be removed at any point, but it can't be removed retrospectively. So if you were consenting at the time, tomorrow you change your mind, it doesn't hang true. So those are some of the common mistakes I see with that. So if the police are involved, does that mean the employer cannot act? Now, I'd like to throw that to the audience. Is there anybody that has an opinion on that? I suspect we will all be in agreement, but I didn't prepare anything else because of that reason. So what are people's view in terms of how much can an employer do if it's a criminal offence?
One of the biggest problems I've seen employers have is getting the cops to come in. Assault matter that the cops had come down, taken statements, spoken to both the parties, and when the HR manager rang them back the next day, they said, oh, look, we're not going to worry about it, you sort it out yourself.
Yeah.
The police are very reluctant to come into workplaces, so it's got to be something fairly serious.
Yeah.
And then, if the police get involved, you're looking at probably 3 to 6 months before they actually get around to doing anything.
Mm.
But yeah, as I say, this case, 2 guys were punching on in the factory, and cops took statements and then said, no, we're not interested. Do it yourself.
So that creates a problem if you're waiting for, you think the police have taken the evidence that you need. You don't want to interfere with a police investigation. And then there can often be quite a long period of time before the police will even make a decision to discontinue a case. So what's people's advice for employers in that situation?
Find out what the cops want to do. Something definitive.
Yeah.
Otherwise, you don't want to run the risk of contaminating evidence, but by the same token, if you've reported to uniforms who are on 4 12-hour shifts, then 4 days off, then annual leave, then court days, it could be weeks and weeks before they actually get around to doing anything.
Yeah.
You got the employees still in the workplace.
Yeah. The other difficulty, of course, as well. Sorry, Michael, were you going to speak?
I was just going to say again that in schools, if you've worked hard to develop a good relationship with your school liaison officer, you can normally jump past some of those blockages if it's happening at that constable level, or there's normally a crime manager or a duty inspector that you've carried some working relationship with that can help you through. But then you've also got, we used to have the ombudsman, now we've got the children's guardian who can also lobby for you to find out where a matter's up to with kids.
Yeah. Yeah.
A lot of support work is done. You've got to do that pre-work and develop the network of professional relationships.
Yeah. And I think, you really have to be careful as an employer not to trample on the evidence that the police need and can get. But I don't have any really solid advice for employers because it is just difficult and on a case-by-case basis. I'm involved in a matter at the moment that has been delayed in the court system over 3 years. So no workplace investigation has occurred because it's in the criminal arena, and they've been waiting over 3 years for their case to go to trial. And when that finishes, depending on the outcome, there may well be a workplace investigation that follows on. And, I dread to think of the welfare elements where that will be, 4 years, gathering evidence, 4 years past when the events initially occurred, and all of the harm that's done in between to that makes it very, very challenging. So not an easy space to be. So act quickly, get the police to do their thing if they can, and if you can't, if they're not, you know, if they're wavering, I'd say get on with your employee related matter, because you could be waiting years for the police investigation to conclude. Okay, so the last 2 questions, which won't take very long. Who's qualified to undertake administrative investigations? Now, this has been subject to interest of mine for many years, and the issues don't seem to go away. It came up as an issue in the Hayden newspaper articles that the investigator involved wasn't qualified because they were not a lawyer, they were not from the judiciary, but in an administrative sense, they're not required to be. So there's nothing in their regulations that say that they needed to be either of those things. And this is a quote from, so Kate Eastman is a barrister in Sydney, and this was a quote from The Guardian a couple of days ago. Workplace investigators do not need any specific qualifications. They could be human resources, they could be public servants, trained investigators, retired police, or lawyers. But what they do need to be is the best investigators, are fair, organised, trained in trauma-informed approaches, and decisive. I particularly like the decisive bit because that suits my personality. But the best investigators are not always lawyers, which I also like. So I've never met Kate, but I'd like to congratulate her on that phrase. And I know that there are there will be some difference of opinion in the people on this call right now about that. But in Australia, the third-party investigations of an individual, it's regulated in each state with a different act. And there's a lot of workplace investigations are not covered by those acts. So it varies. So in Victoria, they're not covered. In New South Wales, some of them are covered and some of them are not covered, which leaves it open to debate. I know Phil will debate that they all need to be licensed, but other people will debate that they don't. In Queensland, workplace investigators do need to be licensed. In the ACT, nobody needs to be licensed. So you can do any undercover work you like in the ACT, you don't need a license. So I think it's just important to understand that there is some conflict over what our legislation does and doesn't permit. But what's important though is this thing about independence. So independence really means that the process can be conducted without interference and the findings are independent of the business itself. So who gets interviewed, what evidence is provided to the investigation, what the outcomes are going to, as in the findings are going to be, needs to be independent from the business. And it needs to be conducted without bias or favoritism to any party. And this is where lawyers can find themselves in conflict. So if a law firm is acting to represent the interests of the employer, then they can't really do the investigation because it creates an unresolvable conflict of interest. And I've come across this a couple of times with law firms where they've done the investigation and then the investigation itself has been challenged. And now and then the lawyers can't act for their client anymore because they're conflicted, because they obviously can't argue that their report was independent of bias because it wasn't. It's done to protect the interests of the business. So on that note, again, with independence, investigators are paid by employers, and that's perfectly okay. Everyone here probably has had that accusation passed at them, but it is okay. We have to get paid from somewhere. What is not okay, however, is the micromanagement of the investigation process. So there are court cases where they have determined that the investigation was procedurally unfair because the employer actually specified exactly who was to be interviewed, in what order and when, what questions were to be asked in the interviews. And I'm sure most investigators on the line would have had an experience of employers wanting the findings changed. Now, that's fine if what they're saying is well, we don't agree and we think you've not really analysed this evidence properly, or you forgot to consider this other thing. If you go back and you look at it and you go, oh, actually, yeah, maybe I didn't give that the weight that it should have been given, that's fine. But if you look at your evidence again and you go, no, no, I definitely think that that's not substantiated, then that's your finding in your report. And that's what gives it its independence. So those things are quite critical.